Hello, and welcome to another practical training. This is Cindy Jimenez from Iconic Power Systems. Today, we are going to talk about the most important concepts you should understand in any terms and conditions. And yes, specifically, the ones we use here at Iconic Power Systems. I know. Terms and conditions don't usually scream exciting video, but trust me, these concepts show up everywhere, and once you really understand them, contracts start to make a lot more sense. By the end of this video, you'll be able to know where to find Iconic's terms and conditions, know which set of terms and conditions to use depending on the situation, and most importantly, start feeling comfortable with the key concepts that drive risk, responsibility, and decision making. This is not legal theory, this is real life, practical knowledge you will actually use. All right, let's start with the basics. First things first, whether you even find Iconic's terms and conditions, they live on our website. And in this slide, you can see the link. Now, when you open that page, you will notice something important right away. Iconic does not use a one size fits all approach. Instead, our terms and conditions are organized based on two very practical questions you should always ask yourself. The first question is, where is the work taking place? If the work is in Alberta, there's a set of terms and conditions for Alberta. If the work is in Ontario, there's a different set for Ontario. That's because laws, risks, and obligations are not the same in every province, and our contracts reflect that. The second question is, what kind of relationship is this? Are we buying goods or services, like equipment, rentals, or professional support? Or are we hiring someone to perform work as part of a project under Iconic scope and direction? That's where the second split comes in. One set of terms and conditions for general purchases and another set specifically for subcontractors. So before you even open a document, pause for 2 seconds and ask, where is the work happening? And what kind of work is this, really? Answering those questions correctly already puts you ahead of the game. Now, let's make this very concrete because this is where people usually hesitate. Let's start with general purchase terms and conditions. You use these when Iconic is acting as a buyer, meaning we're purchasing goods or services, not outsourcing project execution. Think of situations like we are buying materials or components, we are renting equipment, we are hiring a consultant, an advisor, or a professional service, we're purchasing software, tools, or training. In those cases, the other party is a vendor. They deliver something to Iconic, and that's it. A good way to think about it is this. If they show up with an invoice, not a crew, you are probably in general purchase territory. Now, let's talk about subcontractor terms and conditions. You use these when the other party is actually performing work as part of a project. This means they are on site, they are contributing to execution, their work becomes part of Iconic's obligations to the owner or prime contractor. Examples include civil contractors, electrical installation crews, field services, commissioning or testing teams, and any company providing labor, supervising, and execution. In this scenario, Iconic isn't just buying something. Iconic is responsible for how the work fits into the bigger project, and that's why the subcontractor terms are more detailed. They deal with things like flow down obligations, project risk, coordination with the owner or prime contractor, and responsibility for how the work is performed. If you ever find yourself wondering which one to use, here's a simple gut check. Are we buying something or are we trusting someone to perform part of the work? If it's buying, go to general purchase. If it's performing, go to subcontractor. No overthinking required. All right, let's start with the first big concept, warranty. And no, warranty is not just that tiny card you ignore in the box and then panic about 6 months later. At its core, a warranty is a promise. It's a promise that says, what I'm giving you works the way I said it would, and if it doesn't, I will fix it. A warranty answers very simple questions. Is this product or service fit for its purpose? How long is it supposed to work properly? And what happens if it doesn't? Let's use some real life examples. If you buy a fridge and it comes with a 1 year warranty, that means the manufacturer is saying, for 1 year, this fridge should do fridge things like keep your food cold and not catch on fire. If it stops cooling after 3 months because of a defect, the warranty kicks in. If you drop it down the stairs, well, that's a different conversation. Another example, you take your car for repairs. The mechanic might say, this repair is under warranty for 6 months. That means if the same problem shows up again during that time, they're fixing it, not you. So when you hear warranty, think quality, performance, and responsibility for a defined period of time. And that time period is everything. Now, let's talk about how we actually use warranties at Iconic. In Iconic's terms and conditions, warranty is taken very seriously because defective work or defective products can be very expensive. Let's start with general purchases. For general purchases, Iconic's standard warranty period is 12 months. That means the vendor is promising that the goods or services they provide will be free from defects for 12 months. And here's a very important detail. If there is a defect and it gets corrected, the warranty doesn't just quietly disappear. The warranty is extended for another 12 months, starting the date the defect is fixed. So the clock resets. No, sorry, you only have 3 days left situations. Now, one very important thing to watch for in general purchases, sometimes the vendor is not the manufacturer, they're just the supplier. In those cases, we need to make sure they're passing through the manufacturer's warranty and clearly telling us what the warranty is and when it starts. Why does this matter? Because if a product has been sitting in the vendor's warehouse for a long time, the warranty clock may already be ticking, or worse, almost finished. And that can create a big problem. Let me give you a real world type scenario. Imagine we install a transformer or a switchgear component that was not bought specifically for this project. It was existing inventory. It looks fine, it installs fine, everyone is happy. Then, boom, it fails. We go back to the vendor and the warranty has already expired. At that point, Icon is still fully responsible to the owner. We still have to replace the defective equipment, but now there's no warranty coverage, which means the cost of replacing that transformer or that switchgear comes directly out of Iconic's pocket. And those are not small ticket items. Now, let's talk about subcontractor warranties. In projects, warranties do not exist in isolation. They usually flow down from the owner. These days, owners are commonly asking for 12 to 24 months of warranty on work and equipment. That means if Iconic has committed to a 24-month warranty to the owner, we must flow the same warranty period down to our subcontractors. Otherwise, Iconic ends up stuck in the middle, responsible to the owner but unable to recover costs from the subcontractor. So, the key takeaway here is always confirm the warranty period. Always check whether warranties need to flow down and never assume that a warranty exists just because a product exists. Warranty management is not paperwork, it's risk management. All right, next up, indemnification. This is the word that makes people nod confidently, even when they have absolutely no idea what it means. So let's demystify it. Indemnification is about protection. When one party agrees to indemnify another, they are essentially saying, if something goes wrong because of me and you get dragged into it, I will step in and deal with it. And that usually includes paying the costs, covering damages, and very importantly, handling legal claims. Indemnification is most often triggered by third parties, not just the two people who signed the contract. Let's use some real world examples. Imagine You borrow your friend's car. You cause an accident. The other driver doesn't sue you, they sue the car owner. Indemnification is you saying to your friend, if you got pulled into this because of me, I will cover the costs. Another example, you rent a venue for a party. The venue requires you to indemnify them. That means if one of your guests trips, falls, or breaks something, the venue doesn't want to deal with lawsuits or costs caused by your event. You take responsibility for the consequences. So when you hear indemnification, think who protects whom, from what, and in which situations. And remember, indemnification is not about blame in theory, it's about who pays in real life. Now let's bring this back to iconic terms and conditions, because this is where indemnification really matters. In iconic contracts, indemnification is all about risk allocation. In simple terms, if someone causes a problem, they should be the one protecting iconic from the consequences. Let's look at how this works with vendors under general purchase terms. Vendors are required to indemnify iconic for things like personal injury or property damage caused by them, breaches of the contract, and intellectual property infringement. So, if a product or service provided by a vendor causes harm, Iconic shouldn't be left holding the bag. Now, indemnification becomes even more important with subcontractors. Subcontractors are performing work on site, often under Iconic's responsibility to an owner. That means if something goes wrong, an injury, property damage, or a third party claim, the owner will usually come to Iconic first. And that's why Iconic requires subcontractors to indemnify us. It allows Iconic to say, this issue arose from your work. You need to step in, defend the claim, and cover the costs. Another important point, indemnification in subcontractor agreements often flows down from the prime contract. If Iconic has agreed to certain indemnities to an owner, we must make sure our subcontractors are taking on matching obligations. Otherwise, Iconic ends up exposed, responsible upward but unprotected downward. One last thing to remember, indemnification often includes legal fees. Even if a claim never makes it to court, defending it can be costly. So, indemnification is not a formality, it's one of the strongest tools we have to protect Iconic from financial and legal risk. And this leads perfectly into the next concept, liability, where we talk about how big the exposure can actually be. All right, now let's talk about liability. Liability is one of those words people use all the time. What's our liability? Who's liable? But rarely stop to define. In very simple terms, liability means responsibility. It answers one basic question. If something goes wrong, who's responsible and for what? But here's a key thing to understand. Being responsible does not mean being responsible for everything. And this is where people get tripped up. Liability is usually tied to fault. Fault means something went wrong and it went wrong because of your actions or your omissions. Not because you were nearby, not because your name is on the contract, and definitely not because something happened on the same project. Let's use a real life example. Imagine you are at a dinner party. Someone else spills red wine on the white couch. Just because you were sitting in the room doesn't make you responsible for the couch. Responsibility belongs to the person who caused the spill. That's fault-based responsibility. Now let's talk about damages, because liability is always tied to damages. Damages are simply the losses that result when something goes wrong. That could be the cost to fix something, the cost to replace something, or the cost of delays or interruptions. But, and this is very important, not all damages are treated the same way. Some damages are direct. For example, you break someone's phone, the cost of replacing the phone is a direct damage. Other damages are more indirect. For example, because their phone was broken, they missed an important call, lost a deal, and now claim lost profits. That's where contracts start drawing lines. So when we talk about liability, we are really talking about responsibility based on fault for specific types of damages within defined limits. And that's exactly what contracts are designed to do: draw clear boundaries around responsibility. Now that we understand what liability is in general, let's look at how Iconic approaches liability in its contracts and why those limits matter. Yep, let's look at how liability shows up in Iconic's terms and conditions. At this stage, do not worry about numbers, gaps, or insurance yet. We're just looking at structure. In general purchase terms and conditions, liability is written in a relatively simple way. The contract sets out that each party is responsible for its own actions. That responsibility is tied to the goods or services provided, and that the contract defines how liability is allocated between the buyer and the vendor. The goal here is clarity. If something is wrong, the contract tells us who is responsible for what. In subcontractor terms and conditions, liability is more layered. That's because subcontractors are not operating in isolation. Their work sits inside a larger project. So the subcontractor terms link liability to the subcontractor's scope of work, the way the work is performed, and the obligations Iconic has under the prime contract. In other words, liability flows through the project structure. The contract is defining where responsibility starts, where it ends, and how it connects to other parties on the project. So at this point, think of liability clauses as a map. They do not tell you the size of the risk yet, they tell you where the risk lives. Now that we have seen how liability is structured in our contract, we can talk about how Iconic approaches and limits their responsibility. This is where Iconic's position on liability becomes very clear. Iconic's approach is based on fairness, proportionality, and control. First principle: Iconic is responsible only for its own scope of work. We do not accept responsibility for decisions made by the owner, work performed by other subcontractors, or issues outside our contractual scope. Responsibility is tied to fault, not proximity. Second principle: liability must be limited. Iconic does not accept unlimited exposure. Our responsibility should always be proportional to the value of our work. Third principle: not all losses are treated the same. Contracts distinguish between different categories of damages. And Iconic is very deliberate about what it does and does not take on. Fourth principle: risk must align with what can realistically be managed and insured. If risk cannot be controlled or insured, it should not sit with Iconic. And finally, clarity matters. Clear liability clauses protect the project, the relationships, and the business. This is why liability language is never just legal wording, it's a business decision. In the next section, we'll break down what all of this means in practice, including damages, caps, and insurance, and why those details matter so much. Now let's talk about damages, because liability is meaningless without understanding damages. In simple terms, damages are the losses that result when something goes wrong. But not all damages are the same, and contracts make a very important distinction here. Let's start with direct damages. Direct damages are the immediate, out of pocket costs to fix a problem. For example, something breaks, something is installed incorrectly, something needs to be repaired or replaced. The cost to fix or replace that thing, that's a direct damage. Now let's talk about consequential damages. Consequential damages are indirect losses. They are not the problem itself, they are ripple effects. Here's a simple example. You crash your car into someone else's car. The cost to repair their car? Well, that's a direct damage. Now imagine they say, because my car was in the shop, I missed work, lost income, lost a client, and now my business suffered. Those losses didn't come directly from the accident. They came from the consequences of the accident. That's why they are called consequential damages. In projects, consequential damages can include things like lost profits, loss of business, loss of use, financing costs, reputational impacts, and here's a key point. Consequential damages can grow very fast and very unpredictably. So that's why contracts almost always draw a clear line between what damages are recoverable and what damages are excluded. This distinction is critical, especially in construction projects. Let's put all of this together and talk about liability in practice. First, damages. Iconic's position is that we are responsible only for direct damages arising from our own work. We always seek a waiver of consequential damages, and that's an industry standard. That means we fix the actual problem, but we do not take responsibility for indirect financial fallout that goes far beyond our scope. Next, caps on liability. Even direct damages need limits. Iconic's approach is that our total liability should be capped at one times the value of the contract. This keeps risk proportional, predictable, and commercially reasonable. Now let's talk about liquidated damages, especially for delay. Liquidated damages are pre agreed amounts meant to estimate delay impacts, but they still need boundaries. Iconic's position is that liquidated damages must be reasonable and they must be capped, typically around 5%, and in any case, no more than 10% of the contract value. Anything beyond that starts looking like a penalty, and penalties are not acceptable. Finally, insurance. Insurance is designed to cover certain types of risk, such as third party bodily injury, property damage. Insurance does not usually cover poor performance, unlimited delay costs, lost profits, or broad consequential damages. That's why liability caps and damage limitations are essential. If a contract makes Iconic responsible for something insurance doesn't cover, that risk stays with Iconic. And that's exactly what we are trying to avoid. Let's close this training with a real life type scenario. Imagine Iconic is working as a subcontractor on a large project. There are multiple subcontractors, a prime contractor, and an owner. Something goes wrong. There's damage, there's delay, everyone is stressed. Suddenly, the prime contractor is trying to assign blame to anyone and everyone. This is where two things become critical. First, investigation and fault. Liability depends on what actually happened, who did what, who caused what, and whether Iconic was at fault. Being on the same side is not enough. Second, and just as important, what we clearly wrote in our contract. If our terms and conditions clearly say we are responsible only for our scope, liability is fault based, only direct damages apply, consequential damages are waived, and liability is capped, then there is no legal or contractual basis for making Iconic responsible for someone else's mistake or pushing unlimited or unreasonable costs onto us. Contracts do not prevent problems, but they absolutely prevent unfair outcomes. Clear terms and conditions are not about being difficult. They are about making sure Iconic pays for what we control, what we cause, and nothing more. And that's why understanding warranty, indemnification, and liability is not optional, it's essential. And with that, we have reached the end of this training. Thank you so much for taking the time to watch. The goal of this video was simple: to help make terms and conditions less intimidating and more practical and useful in real situations. If you are ever in doubt, or if you need support reviewing language or helping with a negotiation, you can always reach out to me by email. And if you found this video helpful, feel free to give it a thumbs up or let me know in the comments. I would also love to hear from you. Let me know in the comments if there are other topics you would like us to cover in future trainings. Thanks again and see you next time.